Good afternoon. My name is Hae-sun Kim, advisor of Gangnam Labor Law Firm. Today, we're going to discuss with the labor attorney Jung Bong-soo about the recent consulting service that the Gangnam Labor Law Firm provided to one of the management level personnel at the foreign company. So could you explain about the background of the story, please?
Hello, how are you today? This is Bong-soo Jung, Korean labor attorney. Today I like to talk about compensatory leave system. So one of my client company asked me about the case they had. That is, they direct asked the company he want to have some the time off, like after he worked for overtime or holiday work. So it's a kind of a compensatory leave. So but company rejected his request. The reason is he is direct. Also direct is exempt from the application of overtime or like holiday work. So they rejected. So then so they asked me about detailed reason why it is possible to reject the director's request for time off for his extra working or holiday work.
I see. So this recent advice that you have provided is closely related to the Labor Standard Act 57, which is the compensatory leave system, and 63, which is the exclusion from application. I see. So could you explain in more detail about the consulting?
Yes. So labor law stipulated that there is a contractual working hours, like 8 hours per week or 8 hours per day or 40 hours per week. It can be their contractual working hours. So any employee, if they work more than 8 hours per day or 40 hours per week, also if they work on holiday, then they are entitled to overtime payment for those extended working hours or holiday work. But based on mutual agreement between employee representative and the company, company can provide like time off or paid time off or compensatory leave instead of paying the overtime payment. So this is a kind of compensatory leave system. However, there is some exception for this application. That application are the exception are those people like those workers working in agriculture or fishing area, or those people working in intermittent and surveillance work like gardener or driver. Also, last one is some managerial level like director or department head. So they are not applicable for the working hour calculation, because they controlling, they are in the controlling position that they can order their junior workers to do something. So that means also they earned much more money than compared to their junior workers. Usually they also have some incentive pay based on the department performance, something. So that's why some those manager level they are exempt or excluded from calculation of normal working hour system, like for overtime or holiday work.
I see. So this is regarding the Article 63 of the exclusion from the application, especially when the this management level personnel is assigned detailed terms and conditions of the contract. So is this based on our Labor Standard Act is based on the continental law rather than the common law?
I think that's a good point. When we translate the law, there are two major the legal system in the world. One is the British and American system we call common law legal system. Also in Korea, Japan, German, they have some continental legal system. So usually common law legal system, those working conditions are based on mutual agreement in their employment country. So, however, the continental legal system, we have very stipulated working system in the Labor Standard Act. In Korea, we have a strict rule like overtime payment, like when employee work 8 hours per day or 40 hours per week, if they work more than daily limit or weekly limit, then they are entitled to overtime payment. So this also in addition, if they have some agreement, like then instead of receiving their some overtime the payment, they can have a longer leave system instead of receiving the pay. So when company adopted a new system like working hour saving system for overtime or holiday work, then they can use this saved working hours for long-term leave. So for example 2 weeks or 30 weeks. So it is very reasonable and also even convenient for the company. So also it can be one of the welfare system for workers, so because they can take a longer vacation. Yeah.
I see. So since he's not a ordinary staff, I think it's very important that he, before signing the contract, he should check all the detail of the terms and condition about this overtime working hours. Is that right?
Yes, that's correct. Like directors level, they are exempt from application of working hours for overtime, holiday work or nighttime work. So the reason is those people who are in higher position like directors, so they usually earn much more than regular workers. So also in their salary they already include the incentive pay for their department's performance. So according to the Korean Labor Standard Act Article 63, those people are exempt from application of working hours or holiday system. Yeah.
Thank you very much for your comment.
Okay, thank you for watching. Bye bye.